Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In 163. Unit I. Unit 2. Unit 3. Unit IV. Unit V. UNITVI. Unit 7. Unit 8. International Law. Learning outcome. Students will be able to trace historical evolution of international law. Explain international law, differentiate between public and private international law. Understand the sources of international law customs, treaties and ICJ, International Court of Justice, decisions. Appreciate the role of various international human rights conventions, treaties and agreements, understand the interplay between international and municipal laws of India, identify the role of International Court of Justice and International Criminal Court in dispute resolution. A. Introduction. Every state has their own respective laws, domestic laws, which regulate the conduct of its citizens. These laws regulate the private, social, commercial and other activities of individuals. These internal laws, municipal laws, also help in regulating the conduct and affairs of the state machinery. But what happens when there is a dispute between two or more state parties? Which body of law governs their conduct? Which jurisdiction is to be applied in case of disputes related to private parties across different jurisdictions? The world requires a framework through which interstate relations can be developed. The answer to these situations lies in international law. B. Historical evolution of international law. The term, international law, was first coined by the English philosopher, Jeremy Bentham in 1780. The Dutch jurist Hugo Grotius, 1583-1645, is considered to be the founding father of modern international law and has greatly influenced the development of this field. Grotius emphasized the freedom of the high seas, 1625. On the law of war and peace, an idea that rapidly gained acceptance amongst northern European powers that were on a mission to explore the world and colonize it. The origin of international law is embedded in history and can be traced to cooperative agreements between peoples in the ancient Middle East, but the essential structure of international law was mapped out during European Renaissance. Unit 6. Hugo Grotius, Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In. Unit I. Unit 2. Unit 3. Unit IV. Unit V. 164. UNITVI. Unit 7. Unit 8. I. International Law vs. Domestic Law. International law is an independent system of law that exists outside the legal orders of particular states. International law differs from domestic, municipal, legal systems in a number of respects. United Nations, UN, General Assembly consists of representatives of around 190 countries. Although it has an outward appearance of a legislature, but it has no power to issue binding laws. The resolutions passed by UN General Assembly serve merely as recommendations except in certain cases, such as to determine the UN budget, while admitting new members of the UN, and electing new judges to the International Court of Justice, ICJ, along with the Security Council. The international court system does not have absolute jurisdiction in international law. In contentious cases, the ICJ's jurisdiction requires the consent of the particular states that are involved. Also, there is no international police force or system of law enforcement, and there is no supreme executive authority. The UN Security Council may authorize the use of force in specific cases to compel states to comply with its decisions only where there is a prior act or threat of aggression. Any such enforcement action can be vetoed by any of the Security Council's 5 permanent members: China, France, Russia, the United Kingdom, and the United States. The forces involved must be assembled from member states on an ad hoc basis as there is no standing UN military. Therefore, international law is a weak law as compared to municipal law. But unlike municipal law, international law functions in a decentralized manner. All states consider themselves independent and sovereign. The rules of conduct that exists between nations are based on customs of hundreds of years, international agreements and treaties. There is common consent of the community of nations for the enforcement of the rules and principles for international conduct. As per Oppenheim's view, international law is a true law. But according to Austin's view, international law is not a true law as any rule which is not enacted by any superior or legislative authority cannot be regarded as a law. International law and international relations. International law is a distinct part of international relations. States normally conform to relevant rules and principles of international laws while responding to any international situation, if and when it arises. The states are conscious to not be negatively viewed by the international community. The rules of international law are based on reciprocity or self-interest. Breach in international rules by a state may result in loss of its credibility and that may affect it in future relations with other states. For instance, if a state violates a treaty to its advantage, it may induce other states to breach other treaties. This may ultimately cause harm to the state that first violated the treaty. When international rules and principles are followed by states, it creates value of certainty, predictability, and sense of common purpose in international affairs. Globalization in the 1980s resulted in increase in international and regional organizations both in number and influence. This has resulted in expansion of international law to cover the rights and obligations of international organizations. New international law is now frequently created through Textbook of Legal Studies 12-2023-2024. www.cbckademic. NIC. In 165. Unit I. Unit 2. Unit 3. Unit IV. Unit VUNITVI. Unit 7. Unit 8. Processes that require near universal consensus. For instance, in the area of environment, bilateral negotiations have been supplemented and at times been replaced by multilateral ones, transforming the process of individual state consent into community acceptance. This consensus building process has resulted in various environmental agreements and Law of the Sea Treaty, 1982. The Kyoto Protocol is an international treaty aimed at combating global warming. The Kyoto Protocol was adopted in Kyoto, Japan, in 1997 and took effect in 2005. It called for participating countries to reduce their emissions of greenhouse gases and carbon dioxide emissions. International law as a system is complex. Although in principle it is horizontal, being founded upon the concept of equality of states, which is one of the basic principles of international law, but in reality, some states continue to be more important than others in creating and maintaining international law. C. What is international law? Every country is referred to a state in international law. According to Bentham's classic definition, international law is a collection of rules governing relations between states. This original definition omits two vital elements of modern international law, i.e., individuals and international organizations. International law is also called law of nations. International law is a framework of rules and principles binding the relations between states, governing their conduct amongst themselves and other international entities that are legally recognized and between citizens of other nations. It is a system of treaties and agreements between nations that governs how nations interact with other nations, citizens of other nations, and businesses of other nations. It is a form of law which relies on consent-based governance to a great extent, as states are not ordinarily obliged to abide by it, unless they expressly consent to a particular course of conduct. Although certain aspects are exceptions to the consent requirement, such as principles of customary international law or jus cogens. Jus cogens is a Latin phrase that means compelling law. It designates norms from which no derogation is permitted by way of particular agreements. Jus cogens are norms of customary international law which are so important, it cannot be changed through treaties. International law is therefore categorized into a. Public international law. B. Private international law. The study of public international law is distinguished from the field of conflict of laws, or private international law, which is concerned with the rules of municipal law or domestic law of states of different countries where foreign elements are involved. A. Public international law. Public international law is the law that regulates relations between states. Public international law is different from other types of laws because it is concerned with interstate regulation, i.e., it deals in regulating the conduct of one state with another and is not concerned with the relations between private entities, legal and natural persons, and even the domestic laws of any country. Textbook of Legal Studies 12-2023-2024. www. CBCKDMIC. NIC. In. Unit I. Unit 2. Unit 3. Unit IV. Unit V. 166. UNITVI. Unit 7. Unit 8. The primary objective of public international law is to provide for a framework of rules and regulations which help in fostering stable and organized international relations. Some key areas where public international law is applicable: peace and security, human rights, finance, airspace, trade, intellectual property development, sea, weapons, biodiversity, science and security, fisheries, international crimes, climate change, extradition, natural resources. Now, the range of subjects concerned with international law have widened considerably. One of the global international organization that deals with trade between nations is the World Trade Organization, WTO. The World Trade Organization, WTO, from the early days of the Silk Road to the creation of the General Agreement on Tariffs and Trade, GATT, and the birth of the WTO, trade has played an important role in supporting economic development and promoting peaceful relations among nations. Web links. The World Trade Organization, WTO, was established in 1995 and is located in Geneva, Switzerland. WTO has 164 members representing 98% of the world trade. The World Trade Organization, WTO, is the only global international organization dealing with the rules of trade between nations. It is an intergovernmental organization that regulates and facilitates international trade. At its heart are the WTO agreements, negotiated and signed by bulk of world's trading nations and ratified in their parliaments. The goal is to help producers of goods and services, exporters, and importers conduct their business. There are a number of ways of looking at the World Trade Organization. It is an organization for trade opening. It is a forum for governments to negotiate trade agreements. It is a place for them to settle trade disputes. It operates a system of trade rules. Essentially, the WTO is a place where member governments try to sort out the trade problems they face with each other. B. Private international law. Private international law, often referred to as conflict of laws, is a set of rules and principles that govern interstate interactions and transactions of private parties. It is a body constituted of conventions, model laws, domestic laws of states and secondary legal sources. Private international law commonly involves issues like which jurisdiction should be permitted to hear the case, and the law concerning which jurisdiction should be applied to the issues in the case. For example, in marriage laws, there is conflict of laws with respect to marriage-related issues between couples belonging to different jurisdictions. The questions about which legal system and norms should apply forms part of private international law. Textbook of Legal Studies 12-2023-2024. www. CBCKDMIC. NIC. In 167. Unit I. Unit 2. Unit 3. Unit IV. Unit V. UNITVI. Unit 7. Unit 8. Public international law. Private international law. It is a set of rules which governs the intercourse between nations through determining the rights and obligations of the governments of the nations. It comprises of certain rules and regulations which are established or agreed upon by private citizens from different nations who enter into transactions and that would govern them if a dispute were to arise. International bodies harmonizing private laws of different countries. There are certain international bodies which have been working towards harmonizing private laws of different countries and bringing uniformity in their application. The bodies include organizations such as The Hague Conference on Private International Law. It is convened by the government of the Netherlands, originates back in 1893, and focuses on developing conventions on a wide array of aspects of private law. International Center on the Settlement of Investment Disputes, ICSID, International Institute for Unification of Private Law, UNIDROIT. United Nations Commission for International Trade Law, UNCITRAL, it works towards developing model laws and guides regarding international trade and commercial laws, including the UNCITRAL arbitration rules, and so on. Some of the international conventions, model laws in the sphere of private international law which have gained more traction in recent times are the United Nations Convention on Contracts for the Sale of International Goods, CISG, it is also referred to as the Vienna Convention on Sale of Goods. It is a multilateral treaty which provides options for avoiding choice of law issues by providing a framework of accepted substantive rules with respect to contract disputes. It is considered one of the most influential documents in private international law, and nowadays is deemed to be incorporated into any otherwise applicable domestic laws, unless expressly excluded. UNCITRAL Model Law on International Commercial Arbitration. It has provided a framework for domestic laws on international arbitration and is being adopted by an increasing number of countries, with India joining the list in 1996, and Geneva Convention on the Execution of Foreign Arbitral Awards, and so on. Class activity on international law and current events. The aim of this activity is to foster an understanding of the importance of international law to day-to-day international events that appear in newspapers. Students will learn from concrete examples of how people's lives are impacted by international law. Ask students to bring newspapers. They will look through the newspapers to find at least 3 articles, issues, stories, photos, words, etc. related to international law. For instance, topics could be related to international business deal, environmental protection, human rights, war or conflict, refugees, and so on. Students will write a summary of the articles, issues, stories, photos, words that they were chosen. Textbook of Legal Studies 12-2023-2024. www.cbckdemic. NIC. In. Unit I. Unit 2. Unit 3 Unit IV. Unit V. 168. UNITVI. Unit 7 Unit 8. They can refer to the law, convention, act, or statute that would apply to the issue. Example: an article related to racism can be linked to international law, i.e. Convention on the Elimination of All Forms of Racial Discrimination, CEDAW. Students can use Wikipedia, Google, or UN.org to find relevant conventions or acts. No. Article, issue, story, photo, word related to following topics: summary, international law applied; 1 children or youth; 2 international business deal; 3 environmental protection; 4 human rights; 5 war or conflict; 6 refugees. Each student will present on any one of the article, issue, story, photo, word, etc. she or he found interesting and identify the international law that applies to that issue. They will also answer following questions. Why some international laws apply to the issue at hand while others might be ignored? How do countries enforce international law in their country, e.g., Canada, India, etc.? Do all countries enforce international law? Why some countries might choose not to enforce international law? What happens if international law is not applied by the countries? Why is international law needed? Do you think international law helps to resolve the issues it is supposed to? D. Sources of international law. A source of law within a domestic legal system is easier to determine. Within the domestic system, it is considered as something which is not too difficult a process. One may look at the various legislations or statutes provided for by the legislature, and if there is a lacunae in the statute, then one may look at the decisions of the domestic courts. But it is not so easy to pinpoint the sources of international law. Yet, the most authoritative source of international law is Article 38(1) of the Statute of the International Court of Justice, which provides that when a court which deals with disputes relating to international law, it shall apply the following. Article 38(1) of the Statute of the International Court of Justice 1. The court, whose function is to decide in accordance with international law such disputes as are submitted to it, shall apply a. International conventions, whether general or particular, establishing rules expressly recognized by the contesting states. b. International custom, as evidence of a general practice accepted as law. c. The general principles of law recognized by civilized nations. Subject to the provisions of Article 59, judicial decisions and the teachings of the most highly qualified publicists of the various nations, as subsidiary means for the determination of rules of law. Article 38(1) of the ICJ divides the sources of international law into those of a primary and secondary nature. Textbook of Legal Studies 12-2023-2024. www. CBCKdemic. NIC. In 169. Unit I. Unit 2. Unit 3. Unit IV. Unit V UNITVI Unit 7 Unit 8. The primary sources, which the court will consider in its decisions, include conventions, or treaties, customary law, and general principles recognized by civilized nations. Therefore, treaties, customs, and principles of law are the primary sources of international law. Judicial decisions and the teachings of publicists are sometimes referred to as secondary sources or evidence of international law. As per Article 38(1), the third source of international law are general principles of law, recognized by civilized nations. General principles of law are used primarily to fill gaps when treaties or customary international law do not provide a rule of decision, although it is unclear what these general principles of law are. They could be general principles of justice, natural law, analogies to private law, principles of comparative law, or general conceptions of international law. The general principles of law are also found in textbooks, general surveys or manuals, treatises, encyclopedias. It has been suggested by scholars that as new treaties and customary law develop to address areas of international concern not previously covered, the significance of general principles will fade as these gaps in international law are filled. Though Article 38(1) is technically limited in application to the International Court of Justice, ICJ, since the function of the court is to decide disputes submitted to it in accordance with international law and all members of the United Nations are ipso facto members, it is widely accepted that this is considered as enumerating the general norm on sources of international law. Ipso facto is a Latin phrase, which means, by the fact itself. It means that a specific phenomenon is a direct consequence, a resultant effect, of the action in question. Although the provisions of the statute of the ICJ do not suggest any hierarchy, they are generally applied in the following order in case of disputes. 1. Treaties. A treaty, international convention, charters refers to legally binding, written, agreements in which states agree to act in a particular manner as specified in the agreement. Treaties are often complex documents, particularly with regards to those involving more than two parties as they are binding upon them and are to be entered into in good faith. Agreements which are between different nations but without the intention of creating binding obligations are not considered treaties, however they may have political effects. A treaty need not be one consolidated document but may consist of more than one related document. Treaties may be drafted between states by their leaders or government departments depending on the circumstances. How to adopt a final draft into a binding treaty? There are a number of stages that are involved in order to convert a final draft into a binding treaty. The final text has to be adopted in an international conference by way of 2/3 majority. Methods to express consent to be bound by a treaty. Textbook of Legal Studies 12-2023-2024. www. CBCKdemic. NIC. In Unit I. Unit 2. Unit 3 Unit IV. Unit V. 170. UNITVI. Unit 7 Unit 8. A state may express its consent to be bound by a particular treaty in certain cases, the most common of which are consent by signature in certain cases. Treaties may be given force by way of signatures of representatives who have been given the full powers, i.e., authorization in writing from their state to be able to take decisions on its behalf. Consent by exchange of instruments. In some scenarios, consent may be recorded by way of exchanging certain instruments, i.e., documents which contain the terms agreed to by both sides, when these instruments provide that on such exchange they will be in effect. Consent by ratification. Ratification is simply understood to be the act by which a state establishes its consent to be bound by a treaty on the international plane. This was initiated as a measure to ensure that the representative who signed a treaty had due authority, by seeing whether the state agrees to ratify the same. Ratification differs from country to country but usually requires a sign that the state consents to follow the provisions of the treaty. This could be established by assent by the president of the state or require a vote of a majority in the legislature. In multilateral treaties involving a number of countries, ratification is usually the most preferred method of expressing assent, where one party collects the ratification of the others. They are generally considered to be the most accepted as they are in a written form and have been explicitly assented to by the states party to the dispute. 2. Customary international law. The second source of international law is international customs. Along with general principles of law and treaties, custom is considered as the primary source of international law. According to Article 38(1) of the Statute of the International Court of Justice, 1. The court, whose function is to decide in accordance with international law such disputes as are submitted to it, shall apply a international custom, as evidence of a general practice accepted as law. Customary international law consists of rules that come from a general practice accepted as law and exists independent of treaty law. Customary international law refers to binding legal rules that have developed on global or regional levels through continued practice. Customary international law is important in current times when there is armed conflict because it fills gap in treaty law and thus strengthens the protection offered to victims. From where is an observed custom derived and how? An observed custom is extremely fluid and could be derived from the law of nature or mutual consent of states. Textbook of Legal Studies 12-2023-2024. www.cbckdemic. NIC. In 171. Unit I. Unit 2. Unit 3 Unit IV. Unit V UNITVI Unit 7 Unit 8. Custom is usually derived by sifting through many layers and evidences of state practice and opinio juris. Opinio juris. Opinio juris is a shortened form of the Latin phrase opinio juris sive necessitatis, which means an opinion of law or necessity. It is the states' subjective understanding of their legally binding obligations. Opinio juris is the belief that an action was carried out as a legal obligation. Opinio juris serves an important function. It prevents generally unwanted general practice from becoming customary law. Customary international law is comprised of two elements. 1. Consistent and general international practice by states. It is the widespread repetition of similar international acts over time by states, state practice, and 2. A subjective acceptance of the practice as law by the international community, the requirement that the acts must occur out of a sense of obligation. Opinion juris. International custom generally refers to a description of state practice, but only such practice as is accepted by the states themselves as legally required. It develops from a general and consistent practice of states followed by them from a sense of legal obligation. Once a certain practice is understood to be customary law, states are obliged to act as the rule of customary international law prescribes. The test of the existence of a customary rule of law is the extent to which it is observed in the practice and behavior of states. In nutshell, to determine the existence and content of a rule of particular customary international law, it is necessary to ascertain whether there is a general practice among the states concerned that is accepted by them as law, opinio juris, among themselves. The North Sea continental shelf cases confirmed that both state practice, the objective element, and opinio juris, the subjective element, are essential prerequisites for the formation of a customary law rule. This is consistent with Article 38(1)(b) of the Statute of the ICJ. North Sea continental shelf cases. Germany vs Denmark and the Netherlands, 1969, ICJ 1, also known as the North Sea continental shelf cases, were a series of disputes that came to the International Court of Justice in 1969. This case is regarding claims of three parties with regard to a continental shelf in North Sea, wherein both Denmark and Netherlands submitted individual disputes with Germany to the International Court of Justice. The case involved agreements among Denmark, Germany, and the Netherlands regarding the delimitation of areas rich in oil and gas of the continental shelf in the North Sea. The jurisprudence of the North Sea continental shelf cases sets out the dual requirement for the formation of customary international law: 1. State practice, the objective element, and 2. Opinio juris, the subjective element. In these cases, the court explained the criteria necessary to establish state practice, widespread and representative participation. It highlighted that the practices of those states whose interests were specially affected by the custom were especially relevant in the formation of customary law. It also held that uniform and consistent practice was necessary to demonstrate opinio juris. Opinio juris is the belief that state practice amounts to a Textbook of Legal Studies 12-2023-2024. www.cbckdemic. NIC. In. Unit I. Unit 2. Unit 3. Unit IV. Unit V. 172. UNITVI. Unit 7. Unit 8. Legal obligation. The North Sea continental shelf cases also dispelled the myth that duration of the practice, i.e., the number of years, was an essential factor in forming customary international law. Web links. Many other sources have been included to identify and cover more and more customs and practices in the international domain, such as unsigned treaties and United Nations declarations. International customary law is probably the most disputed and discussed source of international law. For example, it is not clear when a particular state practice becomes a legally binding state practice. It is also unclear how one can identify a rule of international custom, or how one can prove its existence. 3. International Court of Justice, ICJ, decisions. Article 59 of the Statute of the ICJ states that the decision of the court has no binding force except between the parties and in respect of that particular case. The court may have jurisdiction to decide cases in which the parties agree to appear before the court, on their own behest, and agree to be bound by the decision of the ICJ. Article 59 of the Statute of the ICJ states that decisions of the ICJ have no binding force except on the parties to the dispute, therefore, past decisions of the ICJ are not binding. However, ICJ does refer to its past opinions when deciding new cases. The ICJ tends to examine its previous decisions, determine which cases should not be applied, and rarely departs from the relevant case law. The court may also be a forum if provided for in a treaty between parties, and in certain cases it is compulsory to refer to the court with regards to certain disputes. The court may also give advisory opinions under Articles 65 to 68 of the Statute of the ICJ to countries. These are not binding but are merely referrals to the ICJ to understand the point of law on the matter. Also, Article 38 of the Statute of the International Court of Justice, ICJ, mentions judicial decisions as a subsidiary means for the determination of rules of law. There are many who feel a departure from the current system is necessary as these are outdated. However, and for the time being, these are the prevalent sources for the purpose of international law. International human rights. International human rights pose a variety of questions under the framework of international law. There are various problems related to enforcement and sanctions with regards to human rights. The Second World War had a profound impact on the development of human rights law as there was a need for a system to give rise to protection of human rights. This led to a wide spurt of activism and literature on the same. Textbook of Legal Studies 12-2023-2024. www. CBCKdemic. NIC. In 173. Unit I. Unit 2. Unit 3 Unit IV. Unit V UNITVI Unit 7 Unit 8. Peace Palace Library. Peace Palace Library is located in The Hague, Netherlands and is one of the oldest libraries dedicated to international law. It has collected international law publications since 1913. The main objective of Peace Palace Library is to service the institutions residing in the Peace Palace, including the International Court of Justice, the Permanent Court of Arbitration, and the Hague Academy of International Law. The library is open to all scholars and students of international law. Let us look into some of the key conventions and treaties promoting and protecting human rights in the international sphere. Article 4 of the International Covenant on Civil and Political Rights, ICCPR, states that there are certain rights that are said to be non-derogable and constitute a special place in the hierarchy of rights such as the right to life, freedom of thought, prohibition of slavery, etc. Also, there are certain rights that have also entered the framework of customary international law like the prohibition of torture, genocide, slavery and the principles of non-discrimination. These have become inalienable rights that do not require any specific treaty to be given effect to. One of the most influential documents in this regard is the Universal Declaration of Human Rights, which deals with various provisions, a few of them being liberty of a person, Article 3, equality before law, Article 7, prohibitions on torture, Article 5, socioeconomic rights such as right to work and equal pay, Article 23, right to social security, Article 25. While the Universal Declaration of Human Rights is not a binding document, per se, there have been many instances where it has been referred to by cases of the International Court of Justice and is an extremely important document for the purpose of international human rights. Another such arrangement was the Vienna Declaration and Programme of Action, 1993. It emphasized that all human rights were universal, indivisible, interdependent and interrelated. This led to the creation of the post of the UN High Commissioner for Human Rights, who would principally be responsible for UN human rights activities. The High Commissioner can make recommendations to other UN bodies and can also coordinate between them. There are several other key legislations and arrangements such as the Convention on the Prevention and Punishment of the Crime of Genocide, the International Convention on the Elimination of All Forms of Racial Discrimination, which read with provisions of the Universal Declaration of Human Rights, give rise to a host of enforceable rights in both treaty and customary international law. Textbook of Legal Studies 12-2023-2024. www. CBCKdemic. NIC. In. Unit I. Unit 2. Unit 3 Unit IV. Unit V. 174. UNITVI. Unit 7 Unit 8. There are various bodies such as the Commission on Human Rights, which is known as the Human Rights Council since 2006. It looks into matters of human rights issues. The Human Rights Council is continuing the work of the previously set up commission by broadening its framework by spreading its area over a wider framework. However, the Human Rights Council has faced criticisms on its political selectivity and failure to objectively review the issues in certain countries. Given the primacy of human rights even in domestic legislatures all over the world, it is almost no surprise that international human rights law is possibly given such a high degree of importance in the world of international law. What are ergounies? Generally, human rights violations are dealt with by the state, country in which they occur. However, there are certain human rights, established under treaty, that may constitute ergounies obligations for the state parties. This means that there are some violations that are so grave that any state, country may take action against such crimes, regardless of whether they occurred in their jurisdiction or not. All states have a shared interest in elimination of such grave violations. One of the most empowering features of international human rights law is that it does away with the borders and limitations of a domestic body and allows the international community to also seek an active role to protect the rights of citizens of other countries. F. International law and municipal law. Can international law be directly applied in the domestic jurisdiction? The interplay between municipal and international law is complex. Some authors believe that international law and the law of the domestic jurisdiction, that is, municipal law of the country, do not intersect and are completely different entities which cannot affect or overrule each other. However, in practice it seems that this does not hold true. Some principles with respect to conflict between international law and domestic law. There are some principles that are clear as this conflict between international law and domestic law is concerned. Municipal law cannot serve as a defense to breach of international law, i.e., you cannot use a domestic law to justify breach of an international one. Neither can one say that their consent to a treaty has been invalidated by way of a change of its municipal law. Similarly, the International Court of Justice has also stated that lack of domestic legislation cannot be brought up as a defense if there is an international obligation on the state not to do a certain act. There have been various cases on the points that state that international law is prevalent over the domestic law. However, that does not mean that domestic legislations carry no force. Some international treaties require that countries adopt domestic legislation in line with the international obligations it has already agreed to. Textbook of Legal Studies 12-2023-2024. www. CBCKdemic. NIC. In 175. Unit I. Unit 2. Unit 3. Unit IV. Unit V. UNITVI. Unit 7. Unit 8. Owing to such requirements, there is blurring of distinction between international and municipal law, and domestic courts have also started analyzing international obligations of states in domestic disputes. Application of international law by countries to its jurisdiction. Each country has their own method of dealing with the application of international law to its jurisdiction. The provisions of international law are often used to supplement various propositions of the domestic law when they are both concurrent with each other. However, whenever there is a dispute between international and domestic law, supremacy of either depends mainly on the forum where the case is being contested. International forums generally give preference to treaty law and other international sources, whereas domestic forums give preference to statutes of the jurisdiction. United Kingdom Doctrine of Transformation. In countries such as the United Kingdom, there is a doctrine of transformation that states that before any international agreement can be considered applicable domestically, it must be transformed into municipal law. This means that the provisions of the treaty need to be transformed into local law by passing a domestic legislation with concurrent provisions as the international obligations. United States of America. In the United States of America, the position is that customary international law is federal law, and if the federal courts in the US determine it to be binding, then it's binding on the state courts as well. However, no act of legislature may be invalidated merely on the basis of violation of customary international law. The U.S. Supreme Court believes that there should be respectful consideration to be given to the interpretation of international treaties. However, a domestic rule to the contrary would be given supremacy over those provisions. G. International law in India. Article 51 of the Indian Constitution specifically states that the state shall endeavor to foster respect for international law and treaty obligations in the dealings of organized peoples with one another. Under Article 253 of the Constitution of India, the Parliament and the Union of India have the power to implement treaties and can even interfere in the powers of the state government in order to give power to provisions of an international treaty. Application of international law in India to its jurisdiction. India generally follows that merely affirming a treaty by way of ratifying it by the assent of the executive unless the treaty requires ratification by way of an act of the legislature. Textbook of Legal Studies 12-2023-2024. www. CBCKdemic. NIC. In Unit I, Unit 2, Unit 3, Unit IV, Unit V, 176, UNITVI, Unit 7, Unit 8. In the landmark case of Kesavananda Bharati v. State of Kerala, it was observed that the court must interpret the provisions of the Constitution in light of the Charter of the United Nations. Evolution of the role of international treaties with relation to the Indian Constitution. There has been an evolution of the philosophy of the role of international treaties to which India is party to with relation to the Indian Constitution. India has dealt with the interplay of international law as fits the need of the day. While any restriction of rights requires the need for an amendment by legislature, enhancing or broadening the scope of such rights is allowed as long as there is nothing to the contrary or similar in domestic law. In the case of Magan Bhai Patel v. Union of India, the court held that if a treaty or international agreement restricts the rights of the citizens or modifies the laws of the state, it would be required to have a legislative measure. E.g., if India is a party to an international agreement to stop the killing of a species of turtle, it restricts the right to trade of certain fishermen by prohibiting killing of the turtle. If this treaty is to be enforced in India, the Indian Parliament needs to pass a domestic legislation regarding prohibition of the killing of such turtle species. If no such right is restricted, then it does not need to have a legislative measure to enact it or give rise to some weight in domestic law in the treaty. It is also very clear of Indian law that international treaties cannot on their own override domestic law. Hence, these treaties which are not enabled by the legislature will not have the same force in law if there is a contradictory law provided for. However, in the case of Sheila Barse v. Secretary Children's Aid Society, the Supreme Court held that India had ratified conventions regarding the protection of children and thus placed an obligation on the state government to implement these principles. This was a case in which there were no contradictory laws, and as they were supplementing the law already in force, the court held that the treaty could be applied directly to Indian law. The most revolutionary of these cases was the case of Vishakha v. State of Rajasthan, in which the Indian courts used the provisions of the Convention on Elimination of All Forms of Discrimination Against Women, CEDAW, to create legally binding obligations regarding sexual harassment. Therefore, India has dealt with the interplay of international law as fits the need of the day. F. Dispute resolution. In the domestic scenario, disputes may be resolved by way of various methods by way of application to court, mediation, conciliation, or even arbitration. In international law, there may be disputes regarding large number of issues relating to treaties or some basic covenants of international law. Treaties often employ mediation, arbitration, and other such dispute resolution mechanisms to arrive at an agreeable decision. In the event such disputes arise between states or even between individuals and the state, there are certain institutions and mechanisms in place to resolve such disputes. Textbook of Legal Studies 12-2023-2024. www.cbckademic. NIC. In 177. Unit I. Unit 2. Unit 3. Unit IV. Unit V. UNITVI. Unit 7. Unit 8. International Court of Justice, ICJ, or World Court. The International Court of Justice, also known as the World Court, is the principal judicial organ of the United Nations. It settles legal disputes submitted to it by states in accordance with international law and gives advisory opinions on international legal issues from UN bodies and agencies. In 1946, the General Assembly of the United Nations enacted the Statute of the ICJ, which gave rise to the institution of the International Court of Justice at The Hague, Netherlands. All members of the UN are party to the Statute of the ICJ by default owing to Article 93 of the United Nations Charter, and non-members may also become parties under this article. The judgment by the ICJ is final, binding on the parties to a case and without appeal. The ICJ has no enforcement powers, but if states don't comply, the Security Council, the organ of the UN primarily responsible for maintaining peace and security, may take action. Jurisdiction of ICJ. The ICJ is thus one of the primary sources of dispute resolution available with regards to international disputes when parties are agreeable to settle them on their own accord. The court may have jurisdiction to decide cases in which the parties agree to appear before the court, on their own behest, and agree to be bound by the decision of the ICJ. The court may also be a forum if provided for in a treaty between parties, and in certain cases it is compulsory to refer to the court with regards to certain disputes. The court may also give advisory opinions under Articles 65 to 68 of the Statute of the ICJ to countries. These are not binding but are merely referrals to the ICJ to understand the point of law on the matter. International Criminal Court. The International Criminal Court, ICC, is a tribunal set up through the Rome Statute in 2002 and shall have the power to exercise its jurisdiction over persons for the most serious crimes of international concern and shall be complementary to national criminal jurisdictions. The ICC has been set up with the purpose of prosecuting criminals for four major crimes: crimes against humanity, genocide; war crimes, crime of aggression; genocide. Genocide means the deliberate killing of a large number of people from a particular nation or ethnic group with the aim of destroying that nation or group. Textbook of Legal Studies 12-2023-2024. www. CBCKdemic. NIC. In. Unit I. Unit 2. Unit 3. Unit IV. Unit V. 178. UNITVI. Unit 7. Unit 8. The ICC may prosecute criminals for crimes committed in a country which accepts the jurisdiction of the court. Thus, only if countries agree to submit to the jurisdiction can the ICC take up certain cases in which the person who has committed the crime is a national of the country or if it was committed in the territory of that country. The cases may be referred by the country directly to the ICC or through the prosecutor of the ICC, who is the person appointed to try cases on behalf of the ICC. The ICC has limited jurisdiction over the ICJ with regards to certain issues pertaining to criminal matters listed under the Rome Statute. The divide is similar to the divide of civil and criminal courts in the domestic context. However, the jurisdiction of the ICC is more restricted than that of ordinary criminal courts. Other dispute resolution mechanisms. Often the treaties entered into by the states themselves lay down the procedure to be followed in case of a dispute. For instance, the General Agreement on Trade and Tariffs provides for a dispute resolution panel within its own provisions. Treaties often employ mediation, arbitration, and other such dispute resolution mechanisms to arrive at an agreeable decision. The United Nations has even created its own forum to deal with issues related to investment disputes in association with the World Bank. These are some of the dispute resolution mechanisms available to resolve international disputes in international law. There are numerous other forums that can be created which are all dependent on agreements between parties and the provisions of the treaties. The ICJ's enabling provisions are also wide enough to deal with most disputes that may arise between member states. Exercise. Based on your understanding, answer the following questions. 1. Distinguish between public international law and private international law. 2. What is the role of UN High Commissioner for Human Rights? 3. Explain the various sources of international law. 4. What happens in case of conflict between a treaty provision and a domestic law? 5. Explain the existing dispute resolution mechanism in international law. 6. In an international conference, aimed at formulating a resolution on an environment issue between the member countries, Indian representative headed for a consent, subject to approval by Indian Parliament. The Parliament, on considering the matter, refused to give assent and thus the terms of resolution were not implemented in India. A. Identify the mode of entering into the treaty opted in the given condition. B. Analyze the situation when it would be binding on the Indian representative to give assent to the resolution. Textbook of Legal Studies 12-2023-2024. www. CBCKdemic. NIC. In 179. Unit I. Unit 2. Unit 3 Unit IV. Unit V UNITVI Unit 7 Unit 8. 2. Class activities. 1. Organize a session of Model United Nations (MUN) in your class. 2. Prepare a report, 1000 words, on the relation between international trade and international law. 3. Emulate a human rights tribunal, war tribunal in your class. 4. Find out whether there is any difference between international humanitarian law and human rights law. Bibliography: Malcolm N. Shaw. International Law, 6th ed. Cambridge University Press, 2008 c. F. Amarasinghe, Principles of the Institutional Law of International Organizations, 2nd ed. Cambridge, 2005. Official documents. Article 38, 1, of the Statute of the International Court of Justice. Article 93 of the United Nations Charter. General Assembly Resolution 48-141, the 20th of December 1993. Report of the United Nations High Commissioner for Human Rights, 1995, A. 49-36. Amnesty International Report, Meeting the Challenge. AI Index, IOR, 40-008-2005. Web links, Textbook of Legal Studies 12-2023-2024. www. CBCKdemic. NIC. In. Unit I. Unit 2. Unit 3 Unit IV. Unit V. 180. UNITVI. Unit 7 Unit 8 Unit 7. Legal Profession in India. Textbook of Legal Studies 12-2023-2024. www. CBCKdemic. NIC. In 183. Unit I. Unit 2. Unit 3 Unit IV. Unit V Unit 7 Unit 8. Legal Profession in India. Learning objectives. Students will be able to trace the history of legal profession in India. Describe the main changes brought about by the Advocates Act, 1961. Explain the professional duties of an advocate, elucidate on women in the legal profession, understand the legal profession and legal education in India, USA and UK, enumerate the opportunities available to law graduates. A. Brief history. The modern legal profession has its roots in the colonial period, where it emerged with the advent of Mayor's Court in Madras and Calcutta in 1726 under the Charter of 1726. However, it was only after the passing of Legal Practitioners Act in 1846 that the doors of legal profession were thrown open to the duly qualified, certified practitioners bearing good character. The practitioners could now practice irrespective of nationality and religion. Women were still excluded from the legal profession. It was through the Legal Practitioners, Women, Act, 23 of 1923 that they were allowed to practice in courts. The Advocates Act, 1961. With an objective to amend and consolidate the law relating to legal practitioners and to provide for the constitution of the Bar Councils and an All India Bar, the Advocates Act was passed in 1961. The main provisions of the Act are: 1. One category of practitioners advocate. After the enactment of the Advocates Act, 1961, all the old categories of practitioners, vakils, barristers, pleaders of several grades, and muhtars, were abolished and consolidated into a single category called advocates, who enjoy the right to practice in courts throughout India. The Act recognizes only one class of practitioners, that is, advocates. Advocates have been classified as senior advocates and other advocates. An advocate on the state rolls is entitled to practice as of right before any tribunal, or authority of India, or any court including the Supreme Court. Advocates. In order to be eligible for enrollment, an advocate must be a citizen of India, at least 21 years of age, and must have an LLB degree from an Indian university. Any advocate enrolled in the state rolls is entitled to practice in all courts of India including the Supreme Court. There is an additional requirement of an All India Bar examination since 2010, which advocates must clear in order to be able to start practice. A foreign national may be enrolled on a reciprocal basis with the country of his citizenship, and his foreign degree may be recognized by the Council for the purpose. In the absence of such. Unit 7, Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In. Unit I. Unit 2. Unit 3 Unit IV. Unit V. 184. Unit V. UNITVII. Unit 8. Reciprocity. Foreign nationals cannot practice law in India. The Bar Council has released a list of foreign degrees that it recognizes. Senior Advocate and Advocate on Record. The Advocates Act makes a provision for two kinds of advocates, i.e., senior advocates and advocates. However, the Supreme Court of India has, in exercise of its rule-making power, made a provision for advocate on record. The distinction amongst them is as follows. Senior advocates. Senior advocates are designated as such by the Supreme Court of India or by any High Court. The court can designate any advocate, with his consent, as senior advocate if in its opinion by virtue of his ability and standing at the bar or special knowledge or experience in law, the said advocate is deserving of such distinction. Section 16, Advocates Act, 1961. A senior advocate is not entitled to appear without an advocate on record in the Supreme Court or without a junior in any other court or tribunal in India. He is not entitled to file a vakalatnama in any court or tribunal, or accept instructions to draft pleading or affidavits, advice on evidence, or to do any drafting work of an analogous kind in any court or tribunal. A designated senior advocate wears a gown with a flap at the back. Advocates on record. Only these advocates are entitled to file any matter or document before the Supreme Court. They can also file an appearance or act for a party in the Supreme Court. No other high court in India has a similar provision. If one wants to practice as an advocate on record, AOR, in the Supreme Court, he or she needs to practice for 4 years as an advocate and thereafter must intimate to the Supreme Court that he has started taking training with a senior advocate on record because he intends to become an advocate on record. After completion of 1 year's training, he has to appear for an examination conducted by the Supreme Court itself. After an advocate passes this examination, he must have a registered office within a radius of 10 miles from the Supreme Court building and a registered clerk. Only an AOR can file a vakalatnama in the Supreme Court on behalf of a client. Any correspondence by the Supreme Court is sent to the AOR. 2. State Bar Councils. The Act has created a State Bar Council in each state with the Advocate General of the state as an ex officio member, and 15 to 25 members elected for a period of 5 years. 2 members are to be nominated by the Bar Council of India from amongst advocates on the electoral roll of the State Bar Council, to discharge the functions of the State Bar Council. Application for enrollment is made to the State Bar Council. Every State Bar Council shall prepare and maintain a roll of advocates in which shall be entered the names and addresses of all who are admitted to be advocates on the roll of the State Bar Council under this Act on or after the appointed day. Functions of State Bar Councils. The functions of a State Bar Council are: A. To admit persons as advocates on its roll. B. To prepare and maintain such roll. C. To entertain and determine cases of misconduct against advocates on its roll. D. To safeguard the rights, privileges and interests of advocates on its roll. A. To promote the growth of bar associations for the purposes of effective implementation of the welfare schemes. F. To promote and support law reform. G. To conduct seminars and organize talks on legal topics by eminent jurists and publish journals and paper of legal interest. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In 185. Unit I. Unit 2. Unit 3 Unit IV. Unit V Unit V Unit 7 Unit 8. H. To organize legal aid to the poor in the prescribed manner. I. To manage and invest the funds of the Bar Council. J. To provide for the election of its members. K. To visit and inspect universities. L. To perform all other functions conferred on it by or under this Act. M. To do all other things necessary for discharging the aforesaid functions. In addition, a state bar council may constitute one or more funds in the prescribed manner for the purpose of a. Giving financial assistance to organize welfare schemes for the indigent, disabled, or other advocates. B. Giving legal aid or advice in accordance with the rules made in this behalf. C. Establishing law libraries. A state bar council may receive any grants, donations, gifts or benefactions for all or any of the purposes specified above, which shall be credited to the appropriate fund or funds constituted under that subsection. 3. The Bar Council of India. The Indian legal profession includes both the practice of law and legal education. To regulate both, the Advocates Act established an All India Bar Council, with the Attorney General and Solicitor General of India as ex officio members of the Bar Council. The All India Bar Council has one member elected to it by each state bar council, and it elects its own chairman and vice chairman. History of Bar Council of India. The Government of India in 1923 appointed the Indian Bar Committee, popularly known as the Chamia Committee, to address the existing disparities in the legal profession. It was chaired by Sir Edward Chamia, a retired Chief Justice of the Patna High Court. The committee in its report stated that it was not practical at that time to organize the bar on an all-India basis. However, the committee suggested the establishment of Bar Council for each of the high courts. The committee suggested that a bar council should have power to make rules in matters such as qualifications and admission of persons to be advocates of the concerned high court, legal education, discipline and professional conduct of advocates, terms on which advocates of another high court could appear occasionally in the concerned high court, or any other matter prescribed by the high court. Giving effect to the Chamia Committee recommendations, the Central Legislature enacted the Indian Bar Councils Act, 1926. The Act was to provide for the constitution and incorporation of bar councils, to confer powers and impose duties on the bar councils, and to consolidate the regulations pertaining to the legal profession. The bar councils could, with the consent of the High Court, make rules for a. The rights and duties of advocates of High Court and professional conduct, and b. Legal education and examinations. The Bar Council of India was established under the Advocates Act 1961. The Bar Council of India performs the regulatory function by prescribing standards of professional conduct and etiquette, and by exercising disciplinary jurisdiction over the bar. It also sets standards for legal education and grants recognition to universities whose degree in law will serve as qualification for enrollment as an advocate. It regulates the content, syllabus, duration of the law degree, subject to which every university can lay down its own provisions. The Council has a legal education committee for this purpose. State Council rules need to be approved by the Bar Council, however, the central government has overriding power to make rules. Textbook of Legal Studies 12-2023-2024. www. CBCKdemic. NIC. In. Unit I. Unit 2. Unit 3. Unit IV. Unit V. 186. Unit V. UNITVII. Unit 8. In addition, it performs certain representative functions by protecting the rights, privileges and interests of advocates, and through the creation of funds for providing financial assistance to organize welfare. The regulatory and representative mandate of the Bar Council for the legal profession and legal education in India is reflected by its statutory functions, which are as follows: to lay down standards of professional conduct and etiquette for advocates, to lay down the procedure to be followed by its disciplinary committee and the disciplinary committees of each state bar council, to safeguard the rights, privileges and interests of advocates, to promote and support law reform, to deal with and dispose of any matter which may be referred to it by a state bar council, to promote legal education and to lay down standards of legal education. This is done in consultation with the universities in India imparting legal education and the state bar councils. To recognize universities whose degree in law shall be a qualification for enrollment as an advocate. The Bar Council of India visits and inspects universities, or directs the state bar councils to visit and inspect universities for this purpose. To conduct seminars and talks on legal topics by eminent jurists and publish journals and papers of legal interest. To organize legal aid to the poor. To recognize on a reciprocal basis the foreign qualifications in law obtained outside India for the purpose of admission as an advocate in India. To manage and invest the funds of the Bar Council. To provide for the election of its members who shall run the Bar Councils. B. Lawyers and professional ethics. The Bar Council of India rules encompass professional standards for lawyers, as laid down by the Bar Council. The key duties and responsibilities of an advocate can be summarized as follows. Professional duties of an advocate. An advocate has a duty to act in a dignified manner, to respect the court, not to communicate with a judge in private and impair impartiality, not to act in an illegal manner towards the opposition, to refuse to represent clients who insist on adopting unfair means. In addition, being in office of the court, an advocate is expected to uphold and maintain the values of the profession. Furthermore, an advocate's duties towards the client include being bound to accept briefs, not to withdraw from service, not to appear in matters where she is a witness, not to suppress material or evidence. An advocate also has to maintain client confidentiality and not to instigate litigation or charge contingency fee depending on success or favorable result of matters. There is a general duty to ensure that her duties do not conflict with the client's interests. An advocate is also expected not to negotiate directly with the opposing party, only through the opposing advocate, and to carry out legitimate promises made. Breach of these rules and standards of conduct lead to disciplinary action against advocates, which may result in suspension or debarment. Source: Bar Council of India, recommended reading. Web links, Textbook of Legal Studies 12-2023-2024. www. CBCKdemic. NIC. In 187. Unit I. Unit 2. Unit 3. Unit IV. Unit V. Unit V. Unit 7. Unit 8. C. Advertising by lawyers. The right of advocates to advertise their services or solicit clients has been a controversial issue in the field of legal ethics and professionalism. In India, advertising by lawyers has been strictly restricted by the Bar Council of India. An advocate is prohibited from promoting himself through circulars, advertisements, touts, personal communications, interviews other than through personal relations, furnishing or inspiring newspaper comments, or producing his photographs to be published in connection with cases in which he has been engaged or concerned. An amendment to this rule allows advocates to furnish certain information on their websites after intimating and taking approval from the Bar Council of India. However, only 5 pieces of information can be put up on the internet, i.e., I, the name of the advocate or the firm, E, the contact details, E, details of enrollment with the bar, IV, his professional and academic qualification, and V, the areas of practice. However, different countries across the world allow advertising by lawyers to varying degrees. The position in the USA is different from that in India, where lawyers have a right to advertise but subject to reasonable restrictions. There are different rules of professional ethics for different states, and there is also the Model Rules of Professional Conduct, which serves as an indicative reference point. Rule 7.1 of the Model Rules prohibits false and misleading communication about services. Rule 7.2 addresses advertising and referrals. Rule 7.3 articulates no solicitation periods, e.g., families and victims of mass disasters are off limits for 30 to 45 days. Lawyers in the US can provide information about class actions, can approach clients by handing out business cards, and can advertise on internet forums. For class actions, solicitation through referrals is permissible. Newspaper and magazine ads and even mass emails are permitted as long as they are not misleading, and no financial incentive is promised. Personal injury ads are commonplace in the USA. Often known as ambulance chasers, These personal injury lawyers are robust in their advertising on billboards, newspapers, flyers, and even distasteful ads on the television. However, ambulance chasing is not representative of professional practice in India, since these class of lawyers are the sort who solicit business by lurking around hospitals or by ads in newspapers and in yellow pages with toll-free numbers and free consultations. However, it is a matter of debate whether the Victorian tradition, UK, has itself done away with the prohibition, should be retained, within which law was considered to be a noble profession and hence advertising was prohibited so as to not tarnish the image of lawyers. The issue of allowing advertising and solicitation by lawyers requires balancing the interest of the public, which includes getting information on legal rights and services through advertisements and enhancement of access to justice and the legal profession on one hand, and the possible misuse of advertising techniques by lawyers, which may lead to a loss of credibility of the profession as a whole. Countries like USA, UK, and France are more flexible with granting permission for legal ads, whereas Hong Kong, Singapore, and Malaysia are moving towards progressive relaxation. In Malaysia, for example, the Legal Profession Publicity Rules 2001 is a simple, comprehensive code that regulates ads in legal and non-legal directories, controls publication of journals, magazines, brochures and newsletters and interviews in the media, bars publicity through clients, and even regulates greeting cards. In Hong Kong, lawyers are forbidden to advertise on television, radio, and in the cinemas, but are permitted to advertise in print media. Recommended reading, web links. D. Liberalization and globalization of legal profession. D. I. Liberalization of legal profession in India. It is the era of globalization that called for removal of barriers in trade and services to liberalize economies. It was in 1990s that for the first time ever, RBI granted permission to 3 law firms to establish their liaison offices in India. Later, in 1995, the General Agreement on Trade in Services, GATS, under World Trade Organization, WTO, came into force. Under GATS, a credible and reliable system for liberalizing legal services was created that applies to the liberalizing the legal profession and corporate legal services also. It is therefore that the Legal Advisory, Legal Documentation Services, Textbook of Legal Studies 12-2023-2024. www. CBCKDemic. NIC. In. Unit I. Unit 2. Unit 3. Unit IV. Unit V. 188. Unit V. UNITVII. Unit 8. Legal Certification Services, Legal Advisory and Information Services and other legal services were liberalized. The Bar Council of India has consistently passed several resolutions between 2002 and 2007 opposing the opening up of the Indian legal profession to foreign lawyers or foreign law firms. In 2011, in a judgment delivered by Bombay High Court on a PIL filed by a non-profit organization, Lawyers Collective, it was held that foreign law firms could not be permitted to set up liaison offices in India. However, contrary to this position, the Madras High Court, in response to a PIL filed by A.K. Balaji, permitted foreign lawyers give advice to Indian clients in India on a fly-in and fly-out mode. D. E. Globalization of legal profession. Globalization, in its literal sense, connotes the integration of economy and legal structure of a nation with the world order. The term, globalization of law, refers to a utopian condition in which the whole world lives under a single set of legal rules. Such rules might be imposed by an international body, adopted by global consensus, or arrived at by parallel development in all parts of the globe. In today's world of increasing international trade and interdependence, the need for transnational law has increased many folds. Since more and more countries open their economy, either partially or completely, there is a growing need to recognize and work towards a uniform system of law. As globalization increases the flow of people and information across borders, there are increasing opportunities for trained lawyers. Typically, the opportunities are available in common law-based jurisdictions such as the United States and the United Kingdom, and to an extent Australia and Canada. However, Unlike many other professions, lawyers trained and licensed in one jurisdiction may not be licensed to practice in other jurisdictions. Lawyers trained in other jurisdictions will have to requalify in order to practice in the foreign jurisdictions. A simple reason for this is that different countries have different legal systems and laws are framed according to the social, political, and civil conditions of the country. Women and the legal profession in India. Indian women were granted the right to take up the legal profession and practice as advocates in the courts of law after the passing of the Legal Practitioners Women Act 23 of 1923, abolishing the bar on women from practicing law. However, this right did not come easily to women in British India. In 1916, the Calcutta High Court, and in 1922, the Patna High Court had held that women otherwise qualified were not entitled to be enrolled as vakil or pleader. In the Patna High Court case, Ms. Hazra, the petitioner, secured a BL degree from Calcutta University. She was refused enrollment as a pleader. She challenged this in the High Court of Patna. The court ruled that the sections of the Legal Practitioners Act referred to males and not females. Since 1793, no woman had ever been admitted to the role of pleaders. The Allahabad High Court took the lead by enrolling Ms. Cornelia Sorabji as the first Indian lady vakil of Allahabad High Court on the 24th of August 1921 by a decision of the English Committee of the Court, as the Administrative Committee was then called, consisting of Chief Justice Sir Grimwood Mears. After the passing of the Legal Practitioners Women Act 23 of 1923, women finally were able to practice as lawyers in India. Since then, although the number of women entering into the profession has increased, gender bias still pervades the profession. According to data tabled by the Law Ministry in Parliament in 2022, only 15.3% of lawyers in India are women. However, recent studies have indicated that gender-based disadvantages are gradually being eliminated, especially in the corporate law sector. Textbook of Legal Studies 12-2023-2024. www.cbckademic. NIC. In 189. Unit I. Unit 2. Unit 3. Unit IV. Unit V. Unit V. Unit 7. Unit 8. F. Legal Education. F. 1. India. Legal education in India. Legal education in India is regulated by the Bar Council of India. The Bar Council of India prescribes the minimum standards of imparting legal education in India. Preceding the liberalization, in 1980, the BCI, University Grants Commission, Law Commission of India, and various state governments have led to the establishment of various law schools in India. This revolution in legal education was pioneered by Prof. N.R. Madhava Menon, who was instrumental in setting up the first law school in India, the National Law School Bangalore. At present there are 24 national law schools in India. There are two ways to obtain a degree to practice law and enroll with the Bar Council. 1. A 3-year LL.B. program which requires a prior undergraduate degree, and 2. A 5-year integrated BA, LL.B. BBA, LL.B. B. SC. LL.B. program which commences immediately after secondary school. Some universities offer both the 5-year and the 3-year degree programs. The Bar Council of India recognizes universities whose degree in law shall be a qualification for enrollment as an advocate. It visits and inspects universities, or directs the state bar councils to visit and inspect universities for this purpose. The Bar Council releases a list of foreign degrees that it recognizes. Presently, there are around 1,721 law schools in India. The reformation of legal education in India, undertaken since the late 1980s at the initiative of the BCI, the University Grants Commission, UGC, the Law Commission of India, and various state governments, has led to the establishment of various national law schools in India in the last 2 decades. This movement was pioneered by Professor N.R. Madhava Menon, who was instrumental in the setting up of the first National Law School. National Law School of India University, NLSIU, was set up in Bangalore in 1987. Its establishment marked the beginning of the reform of legal education in India. There are now 24 national law schools in India, with more being planned. 22 of these now have a common entrance test CLAT, Common Law Admission Test. National Law School University, Delhi conducts a separate entrance test called the AILET All India Law Entrance Test, while a number of other law schools in India have adopted the Law School Admission Test, LSAT. Some other institutions conduct their own separate entrance tests. F. 2. United States of America, USA. In the United States, students after completing a 4-year undergraduate degree in any discipline, write the Law School Admission Test, LSAT, exam. Thereafter, they can apply to a law school and enroll in a 3-year JD. Juris Doctor program. The pedagogical method adopted in law schools involves the case study method as well as the Socratic method. Licensing requirements. Each state in the United States separately administers a mandatory bar exam. Typical first-time passage rates are 72%, New York, 2009, 50%, CA, 2010, and 88%, MA 2008. Bar applicants must also satisfy the character and fitness requirements of the state. Most states also have mandatory or minimum continuing legal education (CLE) requirements. CLE is professional education of lawyers that takes places after they are admitted to the bar and entails minimum hourly commitments which lawyers must undertake in order to maintain their license. Nearly all states require candidates to pass the Multi-State Bar Examination (MBE) and the Multi-State Professional Responsibility Examination (MPRE). Some states also require the passing of the Multi-State Essay Examination (ME) and/or the Multi-State Performance Test (MPT). Foreign lawyers and practicing in the US. As mentioned before, law graduates need to meet all requirements, including writing the bar textbook of legal studies 12-2023-2024. www.cbckademic. NIC. In. Unit I. Unit 2. Unit 3. Unit IV. Unit V. 190. Unit V. UNITVII. Unit 8. Examination of a particular state to be eligible to practice in that state. Foreign lawyers may appear for bar examinations in the US. However, laws from state to state vary in this matter. Students who have completed an LLM may qualify to sit the bar exam in California, New Hampshire, New York, Virginia, North Carolina. The criteria for eligibility to take the bar examination or to otherwise qualify for bar admission are set by each state's bar association. Interestingly, some states may allow some foreign educated lawyers to take the bar examination without earning their degree locally. In such a case, however, foreign educated lawyers must begin the process by getting their law degree reviewed and analyzed by the American Bar Association, ABA. Once reviewed, the application is either accepted or deferred. If accepted, foreign lawyers are allowed to sit for that state's bar exam in much the same way a domestic applicant would. In New York, one of the jurisdictions most open to foreign lawyers, this would allow foreign lawyers to sit for the bar without being required to complete any further law school study in the US. Even if deferred, applicants may be asked to complete coursework at an ABA-approved college before sitting for the bar exam. This coursework usually takes the form of a 1-year LL.M. program at an ABA-accredited school. New York and California are the most popular states for foreign lawyers to give the bar examination owing to the presence of a large number of international law firms involving transnational work, for which an international lawyer's expertise is useful. These are also two of the most difficult bar examinations to clear. Foreign lawyers may also take up work as a foreign legal consultant, FLC. As an FLC, it is possible to advise on home country law and international law but not to appear in court. FLCs are recognized in Alabama, Arizona, Connecticut, District of Columbia, Florida, Georgia, Hawaii, Illinois, Indiana, Michigan, Minnesota, Missouri, New Jersey, New York, Ohio, Oregon, Texas, and Washington. California does not allow FLCs. The American Bar Association, ABA, at a federal level, the American Bar Association acts as a voluntary professional body for U.S. lawyers. With over 400,000 members, it is the largest voluntary professional body in the world and has a significant international profile. Members of the legal profession in other countries can become international associates of the ABA. Founded in 1878, the ABA supports the legal profession with practical resources for legal professionals while improving the administration of justice, accrediting law schools, establishing model ethical codes, and more. Membership is open to lawyers, law students, and others interested in the law and the legal profession. Its goals include serving the members, improving the profession, eliminating bias and enhancing diversity and advancing the rule of law. One of its most important responsibilities is the creation and maintenance of a code of ethical standards for lawyers. The Model Code of Professional Responsibility, 1969, and the newer Model Rules of Professional Conduct, 1983, have been adopted in 49 states, D.C., and in the Virgin Islands. The only exception is state of California. The ABA has been accrediting schools since 1923 and even publishes the internationally reputed ABA Journal. Regulation of legal profession by state bar associations. Lawyers are regulated at state, not federal, level by the state bar or the highest court. Bar associations in the U.S. are divided into two categories, unified and non-unified. In states with a unified bar, the responsibilities of regulating lawyers, admission, discipline, and so on, with activities to support their members as a professional body, lies with the State Bar Association. Membership is mandatory in order to practice in such states. There are 32 states with unified bars, including California, Texas, and Florida. In states with a non-unified bar, responsibility for admitting and regulating lawyers lies with the state Supreme Court or Board of Bar Examiners. In such states, the state bar is a voluntary professional body with activities that can include professional development, lobbying, networking, and charitable programs. States with non-unified bars include New York, Washington, D.C., and Illinois. F. 3. United Kingdom, UK. Legal education. Legal education in the UK consists of a 3-year L.B. directly after secondary school. Graduates from fields other than law and non-graduates can become solicitors, but L.B. is the most straightforward. Textbook of Legal Studies 12-2023-2024. www.cbcacademic. NIC. In 191. Unit I. Unit 2. Unit 3. Unit IV. Unit V. Unit V. Unit 7. Unit 8. Path. Clinical education continues after the L.B. through the Legal Practice Course, LPC, and training contracts. To become a barrister, graduates are required to complete the Bar Vocational Course, BVC, instead of the LPC and then seek a pupillage instead of a training contract. Though there are a number of differences between barristers and solicitors, the most significant one is that barristers can appear in all courts while solicitors can only appear in higher courts if they qualify to become solicitor advocates. Legal education in Scotland is slightly different than the rest of the UK, and L.B. degrees awarded in other parts of the UK are not recognised as part of the qualification process in Scotland, and vice versa. As stated, the most conventional route to becoming a lawyer is by reading law as an undergraduate. To qualify as a barrister or solicitor, students are required to obtain a qualifying law degree. For an LLB to meet the requirements of a qualifying law degree, the course must cover legal research skills in the 7 foundation subjects: Obligations I, Contract Law; Obligations II, Tort Law; Foundations of Criminal Law; Foundations of Equity and the Law of Trusts; Foundations of the Law of the European Union; Foundations of Property Law; Foundations of Public Law. The requirement for completion of the academic stage is a lower second-class UK honours degree. Students who have not taken an undergraduate degree in law can still become lawyers. For students with undergraduate degrees in subjects besides law, it is possible to enroll in the Graduate Diploma in Law course, GDL, which is commonly known as Common Professional Examination, CPE, or a conversion course. This is a 1-year full-time or 2 years part-time course, which covers the 7 foundation subjects, and results in an LLB on passing. Law firms do not look unfavorably on students with non-law undergraduate degrees when recruiting trainees. Foreign lawyers and practicing in the UK. For qualified lawyers coming from outside England and Wales, it is still possible to practice. The Solicitors Regulation Authority, SRA, does not impose any formal experience requirements in order to requalify as solicitors in England and Wales. Some law firms may express their own requirements which can differ from the SRA guidelines. Candidates can take the Qualified Lawyers Transfer Scheme in order to qualify under this jurisdiction. Lawyers coming from EU member states can rely on EU Directive 77/249 in this area. European lawyers can practice to the same level as they could in their own country. However, it is not possible to be a barrister and solicitor simultaneously. G. Opportunities for law graduates. Law is an exciting and challenging profession. Law graduates in India have various options and opportunities open to them after their graduation. A law degree, in addition to being a professional degree, is now considered to be training in a discipline which trains the mind to think analytically and communicate systematically. Following are some of the opportunities available, and opted for by law graduates, to graduates after they obtain their degrees in law. Litigation. Graduates may practice as an advocate in a court of law. This can be achieved by working under experienced advocates or being attached to litigation departments of law firms or companies in order to practice in the courts of India. Law firm practice. Law firms vary in size and practice areas. Law firms may range from boutique law firms specializing in specific areas of law, such as intellectual property rights, Textbook of Legal Studies 12-2023-2024. www.cbcacademic. NIC. In. Unit I. Unit 2. Unit 3. Unit IV. Unit V. 192. Unit V. UNITVII. Unit 8. And tax law, to mid-sized law firms as well as large law firms which are full-service law firms with different practice groups such as general corporate, mergers and acquisitions, employment law, taxation, international trade, insurance, intellectual property, and project finance and infrastructure. Transactional law at law firms typically involves practicing in commercial and economic laws and advising on issues pertaining to a commercial transaction between two or more parties. This would usually include advising on the laws applicable to the transaction, drafting contracts and other documents, and helping clients with the commercial negotiations and the management and execution, i.e., successful completion, of the transaction. Corporate lawyers would also advise on regulatory issues and legal compliance. Centers for Legal Process Outsourcing, LPOs, also have a lot of transnational transactional work. Corporate sector. Large corporations often have an in-house legal practice. An in-house counsel will give legal advice to the company, have expertise in the business of the company, and be responsible for ensuring that the business of the company is being run in compliance with applicable laws, and when required will bring in external lawyers. Several organizations such as commercial banks, multinational companies, investment firms, insurance companies, e-commerce ventures, media houses are hiring law graduates for managing their legal departments. Public policy. Lawyers have an important role in formulating and advising on public policy. Several organizations employ law graduates for policy making and have institutionalized fellowships where law graduates can be research assistants. For example, a law graduate interested in public policy can apply to serve as a legislative assistant under the Legislative Assistants to Members of Parliament (LAMP) fellowship program run by PRS Legislative Research. Institutions such as Competition Commission of India and Securities and Exchange Board of India also employ law graduates for policy making in the respective fields. Law firms have established government policy departments where they employ law graduates for policy research. V. Legal research and academia. Graduates may attach themselves with research centers and think tanks. Law graduates may take up teaching and research as a profession. At least a postgraduate degree in law or related disciplines is expected to build a career in academics. Universities employ postgraduates in law as lecturers, assistant professors at the beginning of their careers. Short-term positions and opportunities as visiting professors, adjunct professors are also available in academia. V. Non-governmental organizations. Not-for-profit organizations, especially organizations with a social justice orientation, have positions for law graduates. These range from small grassroots level organizations to large well-funded organizations. They may be general in nature, providing free legal aid, legal education and legal awareness to more specialist organizations involved in areas such as women and child rights, environmental law, employment laws, consumer rights and public health. Government institutions, government departments, statutory authorities, public sector undertaking and regulatory bodies also provide interesting opportunities to lawyers. Graduates may opt for jobs in the government sector in institutions such as National Human Rights Commission, Law Commission of India, and National Commission for Women etc. V. Further study. Law is an interdisciplinary subject and graduates may opt for further studies in related disciplines such as business, economics, anthropology and sociology. Traditionally, law graduates pursue Master of Laws (LL.M.) degree followed by research degrees such as M.Phil or Ph.D. A variety of opportunities are available in India and abroad for advanced studies in law. V. Judicial services, clerkships. The court system provides several avenues to law graduates. The higher judiciary, that is judges of the high courts and supreme courts, have law clerks cum research assistants who assists a judge in researching for cases, maintaining paperwork, etc. Judicial clerks often sit in court hearings with the judges. Graduates may write the All India Judicial Services examination to avail of positions in the Indian judiciary. Qualifying candidates start in subordinate courts and may then progress to hold offices in the High Courts and even the Supreme Court of India. Textbook of Legal Studies 12-2023-2024. www.cbcacademic. NIC. In 193. Unit I. Unit 2. Unit 3. Unit IV. Unit V. Unit V. Unit 7. Unit 8. X. Judge Advocate General, JAG, Officer. The Judge Advocate General's, JAG, department is the legal branch of the Indian Army. It deals with military-related disciplinary cases and litigation and assists in providing legal assistance to the Army in human rights matters and the rule of law among other things. The department consists of legally qualified Army officers who are educated in military law and provide legal help to the military in all aspects. The department supports the Judge Advocate General, who is the legal and judicial chief of the Army and advises the Chief of the Army Staff of legal matters. The JAG's department is also responsible for emerging fields of military law such as those related to cyber laws, space laws, terrorism and human rights violations. The service rendered in the JAG's department are considered to be judicial service as per the regulations for the Indian Army. Exercises. Based on your understanding, answer the following questions. 1. Write short notes on the following. A. Women and the legal profession. B. Professional ethics for lawyers. C. Eligibility and qualification to practice as an advocate in India. D. Legal education in India. 2. What changes did the Advocates Act bring about in India? 3. Discuss the main points of difference between senior advocate and advocate on record. 4. Compare the rules regarding advertising by legal professionals in India and other countries. 5. How is the Bar Council of India organized? What are its roles and functions? Trace the history of the Bar Council. 6. Compare the rules regarding entry of foreign lawyers in the United States and the UK. Textbook of Legal Studies 12-2023-2024. www. CBC Academic. NIC. In. Unit I. Unit 2. Unit 3 Unit IV. Unit V. 194. Unit V. UNITVII. Unit 8 Unit 8. Legal Services. Textbook of Legal Studies 12-2023-2024. www. CBC Academic. NIC. In 197. Unit I. Unit 2. Unit 3 Unit IV. Unit V. Unit V Unit 7 Unit 8. Legal Services. Learning Outcomes. Students will be able to trace the history of legal aid in India, describe main legislations that govern legal aid in India and abroad, explain the main provisions of NALSA regulations, 2010, elucidate the importance of legal aid as an element of human rights, explain the provisions of Legal Services Authorities Act, 1987 and Legal Services Authorities, Amendment, Act, 2002. In the state of nature, indeed, all men are born equal, but they cannot continue in this equality. Society makes them lose it, and they recover it only by the protection of the laws. Charles de Montesquieu. According to Encyclopaedia Britannica, legal aid is given to persons of limited means, grants, or for nominal fees, advice, or counsel to represent them in court for civil and criminal matters. It aims to create a bridge between the poor and rich in society in order to provide equality to seek justice in the court of law. Legal aid is to ensure that no one is debarred from legal advice and help because of lack of funds. Thus, the provision of legal aid to the poor is based on humanitarian considerations, and the main aim of these provisions is to help those who are socially and economically backward. A. Legal background. In a participatory democracy, it is essential that citizens have faith in their judicial institution that ensures appropriate representation in the court of law and settles the need for equality principle. An impartial and independent judiciary is the guardian of individual rights in a democratic society. For citizens to have faith in their court system, all people must have access to the courts when necessary. Making arrangements to ensure adequate representation in the court of law, for the masses, is an indispensable facet of principles of equality. Citizens agree to a limitation on their freedom in exchange for peaceful coexistence, and they expect that when conflicts between citizens or between the state and citizens arise, there is a place that is independent of undue influence, that is trustworthy, and that has an authority over all the parties to solve the disputes peacefully. It is also the responsibility of the state to ensure that fair and impartial justice is made available at the doorstep of the poor and economically weaker sections, irrespective of their caste, creed, religion, or geographical position, free of cost. The fundamental value of the Indian system of justice is that the stability of our society depends upon the ability of the people to readily obtain access to courts, because the court system is the mechanism. Unit 8 Textbook of Legal Studies 12-2023-2024. www. CBC Academic. NIC. In. Unit I. Unit 2. Unit 3 Unit IV. Unit V. 198. Unit V Unit 7. UNITVIII. Recognized and accepted by all to peacefully resolve disputes. Denying access to the courts forces dispute resolution into other arenas and results in vigilantism and violence. Human rights and human dignity form the premises for the socio-legal foundations of free legal aid. As part of human rights, it is necessary to recognize the principle of equality and ensure access to justice. These foundations reflect the incorporation of legal obligation in international treaties, regional treaties, and the working of monitoring bodies under these treaties or in the national legal systems. B. The Indian legal system, the adversarial system, that the colonial era brought in, made access to justice difficult because it ended the era of informal dispute settlement prevalent in Indian society, leaving aside the quality of justice dispensation in the indigenous mode. The pre-British system was accessible as it was not technical or formal and was conducted in a language known to parties. The Supreme Court in the M.H. Hoskote v. State of Maharashtra, 1978, 3 SCC 544, observed, adjudicature bases itself on the Anglo-American model of dispensing justice. The system compels to collaborate lawyer power, thereby steering the wheels of equal justice under the law by providing free legal aid to certain categories of persons. It is due to the formal nature of proceedings in an adversarial system, requiring pleadings and court fees, that makes access to justice a dream for poor masses in India. In the words of B. Sivaramaya, the observation of Anatole France that the majesty of law treats a millionaire and a pauper sleeping under the bridge alike, held good in the case of the dispensation of justice by the courts modeled on adversarial systems. It is therefore that in an adversarial system, the poor are represented by the advocates appointed by the government to ensure equal representation in the court of law, which forms one of the most important facets of a true democracy. B.I. Legal aid under the Indian Constitution. The Constitution, 42nd Amendment, Amendment Act, 1976 inserted Article 39A in the Constitution, which is as follows: equal justice and free legal aid. The state shall secure that the operation of the legal system promotes justice, on a basis of equal opportunity, and shall, in particular, provide free legal aid, by suitable legislation or schemes or in any way, to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. The wording of Article 39A reiterates that kind of equality which shall promote access to justice for all by creating equal opportunity. That this constitutional guarantee was more often violated than observed is visible in many of the cases brought before the courts, including the Apex Court. Among many crucial reasons for this, it is evident that a technical application of statutory law or constitutional obligation is inadequate. Only a fair procedure can ensure the concept of equality in access to justice. As envisaged under Article 15 of the Constitution of India, the state shall not discriminate against any citizen on grounds of religion, race, caste, sex, place of birth, or any of them. Based on this cardinal principle, no citizen shall, on the grounds only of religion, race, caste, sex, place of birth, or any of them, be subject to any disability. Article 14 of the Constitution of India provides that the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. B.E. Free legal aid under criminal law. Section 341 of the Code of Criminal Procedure, 1898, provided that if a man was charged with an offense punishable with death, the court could provide him with counsel upon his request. However, an amendment in the Code of Criminal Procedure, 1973 facilitated the statutory implementation. Textbook of Legal Studies 12-2023-2024. www. CBCKdemic. NIC. In 199. Unit I. Unit 2. Unit 3. Unit IV. Unit V. Unit V. Unit 7. Unit 8. Of Free Legal Aid. Section 304(1) of CRPC provides that, in a trial before the sessions judge, if the accused does not have sufficient means to engage a pleader, the court should assign a pleader for his defense at the expense of the state. B.E. Free legal aid under international law. International law addresses the provision for free legal services from the perspective of human rights. An explicit provision for legal services is incorporated in the International Covenant on Civil and Political Rights, ICCPR. India has ratified the International Covenant on Civil and Political Rights, which came into force in 1976 and is bound by the international obligation to provide free legal assistance as per the requirements of the Covenant. The Indian Supreme Court has adopted the method of giving effect to international legal obligations when these obligations exist in the Indian legal system expressly. The court also recognized international legal obligations as part of the law of the land when Indian law can be harmoniously interpreted as in conformity with international law. A number of international treaties like the International Covenant on Economic, Social and Cultural Rights, ICESCR, Convention on Elimination of Discrimination Against Women, CEDAW, An international convention on elimination of all forms of racial discrimination may be interpreted as implicitly referring to the need for free legal services while aiming at effective legal remedy and access to justice. There are a number of declarations and principles adopted by the UN which refer to effective legal remedy, of which free legal services, in genuine cases, form an essential component. For instance, Article 8 of the Universal Declaration of Human Rights, UDHR, provides that everyone has the right to an effective remedy by the competent national tribunals for acts violating the fundamental rights granted by the Constitution or by the law. Being a General Assembly resolution, some international law scholars describe UDHR as a soft law in terms of the declaration, encapsulating lofty idealistic notions about human rights. Still, it creates right-centric obligations of norm-creating a character for the members of the international community. C. The Legal Services Authorities Act of 1987. C.I. Brief history. The 14th Law Commission of India Report on Reform of Judicial Administration, 1958 mooted the idea of providing free legal aid to the poor by the state. The report highlighted the responsibility of the legal community to administer legal aid schemes and the state to fund legal representation to the accused in criminal proceedings, appeals, and jails. In 1960, the Union government initiated the National Legal Aid Scheme, which faced financial shortages and died a natural death. In 1973, in the second phase, the Union government constituted a committee under the chairmanship of Justice Krishna Iyer to develop a legal aid scheme for states. The committee devised a strategy in a decentralized mode with legal aid committees in every district, state, and center. In 1980, a committee was constituted at the national level to oversee and supervise legal aid programs throughout the country under the chairmanship of Justice P.N. Bhagwati, then a judge of the Supreme Court of India. This committee came to be known as CILAS, Committee for Implementing Legal Aid Schemes, and started monitoring legal aid activities throughout the country. In 1987, the Legal Services Authorities Act was enacted to give a statutory base to legal aid programs throughout the country on a uniform pattern. Subsequently, the Parliament enacted the Legal Services Authorities Act, 1987 to provide free legal aid to certain categories of citizens. The preamble of the Legal Services Authorities Act, 1987 states, an act to constitute legal services, Textbook of Legal Studies 12-2023-2024. www. CBCKDMIC. NIC. In. Unit I. Unit 2. Unit 3. Unit IV. Unit V. 200. Unit V. Unit 7. UNITVIII. Authorities to provide free and competent legal services to the weaker sections of the society to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities, and to organize Lok Adalats to secure that the operation of the legal system promotes justice on a basis of equal opportunity. The introduction of Lok Adalats added a new chapter to the justice dispensation system of this country and succeeded in providing a supplementary forum to the litigants for conciliatory settlement of their disputes. Society is rapidly progressing and the reflections of the same can be found on all fronts. Given the socio-economic changes in the last decade, the preamble sets forth the need to address the grievances of weaker sections of society. None should be denied justice for being poor or disabled. The evils in the social hierarchy should also not affect anyone seeking justice. C. E. Entitlement to Legal Services. Section 12 and 13 of the Legal Services Authority Act, 1987 deals with the criteria of eligibility for legal services. Section 12 Criteria for giving legal services. Every person who has to file or defend a case shall be entitled to legal services under this Act if that person is a member of a scheduled caste or scheduled tribe, b. a victim of trafficking in human beings or beggar as referred to in Article 23 of the Constitution, c. a woman or a child. D. A person with disability is defined in Clause I of Section 2 of the Persons with Disabilities, Equal Opportunities, Protection of Rights and Full Participation, Act, 1995, 1 of 1996. A person under circumstances of undeserved want, such as being a victim of a mass disaster, ethnic violence, caste atrocity, flood, drought, earthquake, or industrial disaster. Or F. An industrial workman. Or G. In custody, including custody in a protective home within the meaning of Clause G of Section 2 of the Immoral Traffic Prevention Act, 1956, 104 of 1956, or in a juvenile home within the meaning of Clause J of Section 2 of the Juvenile Justice Act, 1986, 53 of 1986, or in a psychiatric hospital or psychiatric nursing home within the meaning of Clause G of Section 2 of the Mental Health Act, 1987, 14 of 1987. Or H. In receipt of annual income less than Rs 9,000 or such other higher amount as may be prescribed by the state government, if the case is before a court other than the Supreme Court, and less than Rs 12,000 or such other higher amount as may be prescribed by the central government, if the case is before the Supreme Court. Senior citizens' eligibility for free legal aid depends on the rules framed by the respective state governments in this regard. In Delhi, for example, senior citizens are eligible for free legal aid subject to the prescribed ceiling of annual income. Any individual above the age of 60 can apply for free legal aid services. D. Legal services meaning and types. D. I. The free legal services include 1. Payment of court fee, process fees, and all other charges payable or incurred in connection with any legal proceedings. Textbook of Legal Studies 12-2023-2024. www.cbckdemic. NIC. In 201. Unit I. Unit 2. Unit 3. Unit IV. Unit V. Unit V. Unit 7. Unit 8. 2. Providing service of lawyers in legal proceedings. 3. Obtaining and supply of certified copies of orders and other documents in legal proceedings. 4. Preparation of appeal, paper book including printing and translation of documents in legal proceedings. Litigation is not a luxury, but it should be used as a last resort. In criminal cases, prosecution is initiated by the state, and when legal aid is provided to the accused, the expenditure of both the parties is managed by the state. Sometimes, it is criticized that legal aid in criminal cases encourages litigation. Therefore, pre-litigation services were introduced as a category of legal services provided to eligible people. Free legal services also include provision of aid and advice to the beneficiaries to access the benefits under the welfare statutes and schemes framed by the central government or the state government, and to ensure access to justice in any other manner. D. E. Legal services can be broadly categorized into the following two types: pre-litigation legal services, and post-litigation legal services. E. Pre-litigation legal services. These days, the number of litigations is increasing day by day, which is against the smooth administration of justice. So far, emphasis was given only on post-litigation assistance or help. Now, it is being realized that pre-litigation legal services are more useful than post-litigation legal services. The pre-litigation legal services include legal education, legal advice, legal awareness, pre-litigation settlement. Post-litigation services include all those services that are required to be rendered by an advocate to his client. EI. National Legal Services Authority. Article 39A of the Constitution of India provides free legal aid to the poor and weaker sections of society and ensures justice for all. Articles 14 and 22, 1, of the Constitution also make it obligatory for the state to ensure equality before the law and a legal system that promotes justice on the basis of equal opportunity for all. In the year 1987, the Legal Services Authorities Act was enacted by the Parliament, which came into force on the 9th of November 1995, to establish a uniform nationwide network for providing free and competent legal services to the weaker sections of society on the basis of equal opportunity. The National Legal Services Authority, NALSA, has been constituted under the Legal Services Authorities Act, 1987 to monitor and evaluate the implementation of legal aid programs and to lay down policies and principles for making legal services available under the Act. In every state, a State Legal Services Authority, and in every High Court, a High Court Legal Services Committee have been constituted. District Legal Services Authorities, Taluk Legal Services Committees have been constituted in the districts and most of the taluks to give effect to the policies and directions of the NALSA and to provide free legal services to the people and conduct Lok Adalats in the state. Supreme Court Legal Services Committee has been constituted to administer and implement the Textbook of Legal Studies 12-2023-2024. www.cbckdemic. NIC. In. Unit I. Unit 2. Unit 3. Unit IV. Unit V. 202. Unit V. Unit 7. UNITVIII. Legal Services Program insofar as it relates to the Supreme Court of India. NALSA lays down policies, principles, and guidelines and frames effective and economical schemes for the state legal services authorities to implement the legal services programs throughout the country. Primarily, the state legal services authorities, district legal services authorities, taluk legal services committees, etc., have been asked to discharge the following main functions on regular basis to 1. Provide free and competent legal services to the eligible persons. 2. Organize Lok Adalats for amicable settlement of disputes. And 3. Organize legal awareness camps in rural areas. NALSA Regulations, 2010. In 2010, the National Legal Services Authority, NALSA, of India adopted the National Legal Services Authority, Free and Competent Legal Services, regulations in the exercise of its power under Section 29 of the Legal Services Authorities Act, 1987. The regulations are applicable to the legal service committees of the Supreme Court, High Courts, the states, districts, and taluks. Some broad features of the relevant regulation are as follows. Selection of panel lawyers. The legal services institution is vested with the authority to invite applications from legal practitioners with requisite professional experience to indicate the types of cases as they may be entrusted with. The panel shall be prepared by the executive chairman of the legal service institution in consultation with the Attorney General, for Supreme Court, Advocate General, for High Courts, Government Pleader, for districts, taluks, and the Bar Association President. The legal practitioner shall have 3 years or more of experience at the bar for being considered for empanelment. Personal traits like competence, integrity, suitability, and experience shall be considered. Separate panels shall be maintained for different types of cases. The regulations also provide for retainer lawyers. The panel has to be reconstituted every 3 years without disturbing the work of panel lawyers already representing ongoing cases. In such cases where the panel lawyer wishes to withdraw from a case entrusted to him shall communicate this to the member secretary and the latter may permit him to do so. The panel lawyer is barred from taking any fee, remuneration, or other valuable consideration from any person for whom legal services are rendered under the regulation or act. The panel lawyer may be withdrawn from a case or his name removed from the panel on account of non-performance of duties satisfactorily or for actions against the object and purpose of the act or regulations. Payment of fee. The regulations specify the rules regarding the payment of fees for panel lawyers which shall be in accordance with the state regulations without any delay on receipt of completion of proceedings for them. It suggests a periodic revision of honorarium for the different types of services provided by panel lawyers in legal aid cases. Senior advocates. The services of senior advocates may be availed, if the chairman of the legal services institution forms an opinion to that effect in cases of great public importance and where serious threat to the life and liberty of the applicant exists. F. The Legal Services Authorities Amendment Act 2002. The Parliament of India realized that litigation-oriented legal services cannot bring out desired results. Therefore, for encouraging pre-litigation legal services, especially in public utility service. The Parliament Textbook of Legal Studies 12-2023-2024. www. CBCKdemic. NIC. In 203. Unit I. Unit 2. Unit 3. Unit IV. Unit V. Unit V. Unit 7. Unit 8. Has made certain amendments in the Legal Services Authorities Act by passing an act known as the Legal Services Authorities Amendment Act 2002. The purpose of this amendment is to bring out certain changes in the Legal Services Act 1987, hereinafter referred to as the Principal Act, especially I. The establishment of permanent Lok Adalats to settle disputes concerning public utility services at pre-litigation state. E. Pre-litigation conciliation and settlement pertaining to public utility services. FI. Public utility service means any transport service for the carriage of passengers or goods by air, road or water. Or E. Postal, telegraph or telephone service. Or E. Supply of power, light or water to the public by any establishment. Or IV. System of public conservancy or sanitation. Or V. Service in hospital or dispensary. Or V. Insurance service, and includes any service which the central government or the state government, as the case may be, may, in the public interest, by notification, declare to be a public utility service for the purposes of this chapter. F. E. Permanent Lok Adalat Important Provisions. Permanent Lok Adalat Important Provisions 1. The Permanent Lok Adalat shall, during conduct of conciliation proceedings, assist the parties in their attempt to reach an amicable settlement of the dispute in an independent and impartial manner. 2. It shall be the duty of every party to the application to cooperate in good faith with the Permanent Lok Adalat and to comply with the direction of the Permanent Lok Adalat to produce evidence and other related documents before it. 3. In case the parties reach at an agreement on the settlement of the dispute, they shall sign the settlement agreement and the Permanent Lok Adalat shall pass an award in terms thereof. Where the parties fail to reach at an agreement, the Permanent Lok Adalat shall decide the dispute. 4. Procedure of Permanent Lok Adalat. The Permanent Lok Adalat shall, while conducting conciliation proceedings or deciding a dispute on merit under this Act, be guided by the principles of natural justice, objectivity, fair play, equity and other principles of justice, and shall not be bound by the Code of Civil Procedure, 1908, 5 of 1908, and the Indian Evidence Act, 1872, 1 of 1872. 5. The award of Permanent Lok Adalat shall be final and deemed to be a decree of a civil court. Other initiatives. Legal Service Mobile App. To enable equitable access to justice, NALSA has launched Legal Services Mobile App on Android and iOS versions to enable easy access to legal aid to common citizens. Disha Scheme. The Department of Justice, DOJ, has launched a comprehensive, holistic, integrated and systemic solution on access to justice at pan-India level through a scheme titled Textbook of Legal Studies 12-2023-2024. www. CBCKdemic. NIC. In. Unit I. Unit 2. Unit 3. Unit IV. Unit V. 204. Unit V. Unit 7. UNITVIII. Designing Innovative Solutions for Holistic Access to Justice, Disha, being implemented from 2021-26. All access to justice programs have been merged under the Disha scheme and upscaled to all India levels. G. When can legal aid be denied or withdrawn? Legal aid can be denied at the initial stage before the application for legal aid is accepted. It can also be withdrawn at the later stage after the application has been accepted. Legal aid can be denied or withdrawn in the following circumstances. 1. Legal aid can be denied if a person is found ineligible under Section 12 of the Legal Services Authorities Act, 1987. 2. Legal aid can be withdrawn if the aided person who applied under the income category is found to possess sufficient means. 3. Legal aid can be withdrawn where the aided person obtained legal services by misrepresentation or fraud. 4. Legal aid can be withdrawn where the aided person does not cooperate with the legal services authority, committee, or with the legal services advocate. 5. Legal aid can be withdrawn where the person engages a legal practitioner other than the one assigned by the legal services authority, committee. 6. Legal aid can be withdrawn in the event of death of the aided person except in the case of civil proceedings where the right or liability survives. 7. Legal aid can be withdrawn where the application for legal service or the matter in question is found to be an abuse of the process of law or of legal services. Web links make the link click. H. Legal aid in context of social justice and human rights. There are millions of people who are denied human rights only because they cannot afford the cost required for the enforcement of their rights. Merely talking about human rights from an elitist platform is not sufficient. In order to do social justice for them and to make human rights meaningful, legal aid becomes essential. Human rights which cannot be enforced due to poverty are meaningless and worthless. A right to access to justice is sine qua non for social justice. Access to justice itself is one of the most basic human rights, and without it, the realization of many other human rights may become difficult. Indeed, the right to access justice or legal aid is evolved by judicial creativity for the benevolence of poor persons. Now, neither is it possible nor is it proper to isolate the right to legal aid from a range of human rights. The reason is obvious: mere declaration and passing of resolutions about human rights are not enough. The guarantee for the enforcement of these rights is equally essential. Hence, it will not be incorrect to say that the right to legal aid stands first in the species of human rights. Human rights are only mere pious declarations without legal aid. They become lucrative only when they are enforced. The right to legal aid enables the accomplishment of these human rights and makes them worthwhile for the poor masses in the world. In the present legal system of most countries, justice is not given but sold. In the present legal system of most countries, justice is not given but sold. The consumers of justice have to pay the remuneration of counsel, and bear expenditures for court fees, and also other contingent charges. Indeed, poverty is an obstacle in the way of getting justice, and due to this reason, the poor become a sufferer of social injustice. Legal aid is only a way for providing social justice to all. Legal aid, indeed, is an integral part of human rights and it requires urgent considerations, otherwise, Textbook of Legal Studies 12-2023-2024. www. CBCKdemic. NIC. In 205. Unit I. Unit 2. Unit 3. Unit IV. Unit V. Unit V. Unit 7. Unit 8. There is an apprehension that someday the patience of poor persons may be exhausted and that will endanger world peace. Exercise 1. Discuss the main provisions for free legal aid under the Indian Constitution. 2. Mention any 4 categories of persons entitled to free legal aid under the Legal Services Authority Act by the Central Authority. 3. How has the amendment of the Legal Services Authorities Act in 2002 widened its scope by establishing permanent Lok Adalats? 4. Discuss 3 main provisions of National Legal Services Authorities Regulations 2010. Textbook of Legal Studies 12-2023-2024. www. CBCKdemic. NIC. In. Unit I. Unit 2. Unit 3. Unit IV. Unit V. 206. Unit V. Unit 7. UNITVIII.